What are the top 3 changes according to you that came in under the RIA?
Talking about the three,
Sure.
this I would say takes the lead.
How is it relevant for someone who's based in the US on a valid visa category? Can you tell us a little bit about the EB-5 Reform and Integrity Act?
It has just dynamically changed.
What exactly is staggered investment? Is it allowed by the government? The most favorite question. What exactly is the meaning of source of funds? Hi, my name is Akshat Gupta. I work as Director of Business Development at US Immigration Fund, also known as USIF. USIF is an experienced US EB-5 regional center. Over the years, they've helped more than 6,000 investors and their families achieve the US permanent green card via the EB-5 visa program. Today on our podcast, we have a very special guest, Mr. Rohit Turkhud, Counsel, CSG Law. Rohit has an experience of over a decade helping investors in the EB-5 visa program. He is fluent with Hindi, English, Marathi, Gujarati, and most famously, he is known as the man with the bow tie in our industry. Above all, he is a dear colleague. Thank you so much, Rohit, for joining us today.
Akshat, thank you so much. It's a pleasure to have been invited by you and USIF to be part of this podcast. Pleasure to be here.
In today's podcast, we look forward to covering various topics such as what is the current state of the EB-5 Reform and Integrity Act? What are economic and legislative factors involving timely petition? And what are the long-term impacts or benefits of having your priority date logged in as soon as possible? Rohit, can you tell us a little bit about the EB-5 Reform and Integrity Act?
The Immigration Reform and Integrity Act, also called RIA very casually, was enacted on March 15th, 2022. And it has changed the landscape of EB-5 in a very positive manner since then. You have certain changes that have been introduced, which are great from an investor's perspective. There are obligations on the regional centers like USIF, which have become more demanding, which is great again from an investor's perspective, because in my opinion, it improves the quality of each regional center's offerings as well. But that law is now in effect. It's in effect until September 30th, 2027. And hopefully, all of us in the industry are hopeful that it's going to be a permanent extension at some point in time of the Reform and Integrity Act.
Sure. What are the top 3 changes according to you that came in under the RIA?
Okay, so the first one, of course, from the investor's perspective, the amount increased from $500,000 to $800,000, which was a big jump, but not unexpected, not unusual, considering it had not been changed since the inception of the law in 1990. So that went up to $800,000. The other change was a change in the definition of what is a targeted employment area.
Yeah.
The targeted employment area actually refers to the amount of money that you're investing. So they modified the two that already existed and added a third.
Sure.
So in the past, or when the law was actually enacted in 1990, the goal was to increase employment in rural areas. Unfortunately, rural areas, I wouldn't say became sidelined, but took second place to what we call as high unemployment areas. And so these are the two that were existing. They've been modified, and I'll come to that in a second. The third group that got added was infrastructure projects with the participation of the government. Interestingly, I don't think there are any infrastructure projects yet. I will again qualify that statement. That's one of my colleagues at CSG said that they have actually been handling the first infrastructure project that is coming to the market. So we'll see how that plays out. But the difference between the rural and the high unemployment, and I'm probably going a little step ahead, but I'm not going into the ABCs over here. The rural projects have been given a priority to promote growth and economic development in the rural areas. So if you're investing in a rural project, you will have a 20% visa set aside and priority processing, which we know has not been defined by the immigration. So there's no question of knowing what is priority processing. Sure. And if you're in the high unemployment area, you have a 10% visa set aside with no priority processing. Very commonly, or I should say a common mistake or just a misnomer, is everybody just says targeted employment area for high unemployment areas. And that's not correct. Your targeted employment area is the house that you live in, and one room is the rural, and one room is the high unemployment. Okay, so just to clarify.
Sure. Can you tell us a little bit about what exactly is adjustment of status and how is it relevant for someone who's based in the US on a valid visa category?
Sure, and that probably is the single most important change under RIA. You were talking about the three.
Sure.
This, I would say, takes the lead. It has just dynamically and dramatically changed EB-5 processing and EB-5 investing for those who are in the US. It allows somebody who's in the US on a valid visa to be able to apply for the green card, because it's the adjustment of status that is actually the green card application. The EB-5 petition is the underlying application, but you can file the adjustment of status, and with the adjustment of status, you get two benefits, which are exactly what you want from a green card. One, the ability to work without any restrictions in a legal job. And the reason why I stress legal job is because, as many people know, many states in the US have legalized the use of marijuana, the medical use, even the entertainment value use. That has not been legalized for immigration. So if you think that your EAD, employment authorization document, gives you a carte blanche, it does not. That's the reason why I've now started qualifying and saying legal job. So that's one aspect. And the second huge advantage that you get is advanced parole, which is a travel document. They're two separate documents. One must remember that. Okay. But those are the two huge benefits that you get. And just as a general rule, adjustment of status gives the investor and the applicant much greater protections than doing the complementary side, which would be the consular processing. Because when you're doing adjustment, you're in the US, you have no interview, you are not subject to the uncertainties of a consular processing interview, because those things can vary. So adjustment of status, the biggest present that RIA gave to any of the investors.
I'm sure. I do agree. And I think we've seen a huge demand, especially after the introduction of this amendment or this provision to be able to file the adjustment of status. What would be the average timeline that you've seen with your clients post RIA or RIA, as you call it, in terms of securing the work and travel permit?
It's gone through up and downs. Right now, once you file the adjustment of status, you're seeing the employment authorization document come in about 3 to 4 months. The advanced parole is taking about 6 to 9 months. Having said that, the immigration always likes to throw a little bit of a curveball, which means they can sometimes issue what we call a combo card, which is the EAD and the advanced parole together. And that seems to be coming in about 4 to 6 months. Problem is, there is no way for us to predict and tell our clients which one they're going to get. Are they going to get separate documents, or are they going to get a combo card? Not only that, I've had clients where we've had to apply for extensions of the combo card, and the immigration then decides to issue separate documents. So it's extremely frustrating for us, and I'm sure it's much more so for our clients and investors. And strangely enough, I think 3 letters that I half jokingly tell my clients, which I know best, are IDK. I don't know. And that just unfortunately happens to be the truth, and the immigration, I think, likes it that way.
Okay. But certainly for an investor who's in the US currently, while they have to wait for a period of 2 years approximately to get their conditional green card, it's a huge blessing because you're able to derive the benefit of having the freedom to work and travel without a restriction by the virtue of getting this work and travel parole.
Completely agree. I mean, the clients also need to discuss with their attorney any restrictions on travel till they actually get the advanced parole document in their hand. There's a difference between receiving the approval notice and receiving the actual document. I cannot tell you how many times I answer this question with my clients. Oh, we've received the approval notice. Can I just now do what I want? No. You've got to wait till you get the actual document. And there can be many a slip between the cup and the lip where the postal service will not deliver it, will deliver it to the wrong address. My basic guideline, do not function or do not take any actions without discussing it with your immigration attorney. That's really important.
They say in the world of EB-5, your immigration attorney is like your God, because they end up being your go-to action or a go-to person to talk to whenever you have any issues, and they're your guide. Regional Center, of course, takes care of the investment. We take care of the job creation. But I think investors confine and rely a lot on their immigration attorney, and that's where it brings in so much trust, and you would want to work with a good and experienced EB-5 immigration attorney.
I totally agree with you on that. There's no question about it. And I cannot even begin to tell you how many times the clients forget that.
Yeah.
And they take their own decisions, and then sometimes the immigration attorney is trying to figure out how to clean up a mess. So it might be easier not to do that.
Sure.
Yeah.
So Rohit, we have something called the Visa Bulletin, which is issued every month. Currently, the most recent Visa Bulletin from February says that all targeted employment area categories, whether it be rural, high employment area, or infrastructure, continue to be current, especially for people who come from India, China, Vietnam. In the interest of our audience, could you please let us know how is this category being current so relevant, and what is the repercussion of this getting retrogressed, which is probably expected to happen sometime this year?
Okay, great question. I'm going to try and take small bites at it.
Sure.
So first of all, when you said people from India,
Yeah.
let's clarify, we're talking about people who are born in India.
Correct.
Right? We're not talking about somebody who has an Indian passport only.
Yes.
Because you could be born in some other country, and by operation of law, you don't get the citizenship of that country, and you are an Indian citizen.
Yes.
But it's the country of birth that controls for all immigration purposes. It doesn't matter whether it's EB-5 or not. There is an issue sometimes of what's called cross-chargeability, but I'm not getting into that because it's not relevant right now.
Do
Okay?
you have my cue cards by any chance? Because the next question was about country quota and allocation. Just kidding.
So
yes,
I'm a
please.
mind reader. What can I tell you?
Okay.
So I think, so first of all, I just want to clarify that. Second, before we even get into a discussion, what is retrogression?
Yes.
Retrogression in very simple terms means your demand is more than the supply.
Yes.
So supply is limited of visa numbers.
Yeah.
And that supply is counted as the visas are issued, right? So we know that there are lots of applications filed out of India,
Yeah.
as are out of China, etc. But we just limited to India for now.
Yeah.
But the question is the demand. So when the demand for the visa numbers outstrips the supply, that's when the visa numbers get retrogressed or backward, or they put a hold. It's simply like saying there are only so many people you can fit into a car.
Yeah.
Right? If it's a 5-passenger, in India, you might be able to get 7 or 8 in the same car. But if you're not and you're doing a normal 5, the minute the 6-passenger comes in, you've got to wait for the next car to come to pick you up.
Yeah.
So that's the simple explanation of a visa number retrogressing. Now, for EB-5 purposes, again, I'm oversimplifying this.
Yes.
But when you say it's current, means that you can file your adjustment of status along with the EB-5 petition concurrently or at the same time.
Sure.
And like I said earlier, that's the biggest boon that RIA has given. No question about it, which is the reason why I think most of us see an uptick in the number of applications despite the increase of the amount from $500,000 to $800,000.
Sure.
So that's something that we have to remember.
Yes.
If there is retrogression, you can always file the EB-5 petition, which is a separate application. There's no limit on the number of applications or petitions that you can file for EB-5.
Sure.
There is a limit on the number of adjustment of status applications that you can file based on the visa bulletin.
Sure.
Right? So the visa bulletin says it's current. Now, if it's not current where the demand outstrips the supply, you then have what's called a cutoff date or a priority date.
Okay.
That's your waiting line. The priority date essentially is referring to the date that your EB-5 petition was submitted to the Immigration Service, or rather, which was received by the Immigration Service.
Sure.
So when you get a receipt, you will see an item over there which says filing date or priority date. That's the date that one needs to look out for.
Sure.
As long as the application or the visa bulletin says current, it doesn't matter. You're not worrying about it.
Sure.
But when it starts getting cut off, that's when you're going to start getting concerned,
Yeah.
because you know that you cannot file the concurrent adjustment of status.
Sure.
Again, without getting into the weeds, there is in the same visa bulletin,
Yeah.
it's called the final action date,
Yes.
which refers to the date when the visa can be issued because there's availability.
Yeah.
The chart that follows that is the filing date, and the filing date can change, and that again you've got to monitor, because you might be able to file your adjustment of status if that chart allows it for that date. So
Okay.
I realize I probably confused the audience. That's the reason why immigration attorneys exist, and
I
that's
was
the
just
reason
about
why
to say
the
the same.
investor should go and talk to the immigration attorney
Sure.
to figure that out. And that has to be monitored every month.
Sure.
You've got to be careful about it because there's so many variables over there as well.
But simply put, since there's been so much chatter about the fact that in the January visa bulletin there was this hint from the government that there could be a retrogression sometime this year. So I guess the most basic advice to everyone here is, if you're someone who's looking at filing EB-5, if you are on a valid visa category in the US, if adjustment of status is something that you're looking at, now is the time.
Absolutely. Now is relevant to every case.
Yeah.
I will agree, and I'm sure we'll get into an additional discussion as to what now means.
Sure.
But yes, I totally agree with you that you should be doing that. And even if for some reason you're not able to file the adjustment of status concurrently, would certainly encourage my clients to file the EB-5 petition so that you get a priority date, which is then connected back with the cutoff date.
Sure.
Again, I'm not sure that this podcast is meant to delve into that so much in that detail, but suffice to say, it's something that should definitely be discussed with their attorney.
And absolutely, for further details, they should reach out to you so that you can guide them and let them know in
Happy
detail.
to do that.
Awesome. We spoke about allocations and caps, and since you're reading my cue cards and you're well ahead of the curve, in the interest of the audience, I want to understand this. What are the total number of EB-5 visas available in a year? And if I am Indian born, whether I'm in India, whether I'm in the US, or whether I'm in Singapore or any part of the world, what is the country cap that each country has under the EB-5 Reform and Integrity Act?
Great. So to step back, the global allocation just for EB-5 is 10,000 visas globally.
Okay.
Right? No country is allowed to use more than 7.1%.
So that's
which means
about
700 visas.
Okay.
Each individual is a visa number.
Okay.
It's not based on family. It's one per person. Right?
So if I'm a family of 4, I'm using 4 out of that 7.
That is exactly correct.
Okay.
And we know for sure,
Yes.
which connects back to your earlier question about retrogression.
Sure.
We know for sure that there are at least over 1,000 petitions, EB-5 petitions, filed by those born in India over this period of time.
Sure.
However, because they've not been processed, because they've not been approved, maybe because of other variables, those visas have not been issued and therefore not counted in the quota. So if those were issued and they get counted in the quota, you're suddenly going to run out of that 700 number. And when you run out of that, you're going to end up with a possible cutoff date or a priority date that needs to get adjusted.
Got it.
So that's what you need to be careful about and monitoring.
Sure.
Yeah.
And I mean, since the start of EB-5, because it is obviously not a new visa program. It's been there since 1990. I think we've seen in the pre-RIA world, we've seen countries like China get retrogressed up until 6 years, 8 years, and obviously India is to about 4 years. So that again brings back the point that as veterans, as someone like you who's a veteran in this industry, you've already seen the concept of backlogs kick in, which means it's very eventual for it to happen even in the post-RIA world. And if you are a conscious customer for EB-5, certainly there is no better time to do it as of right now.
Totally agree.
Okay, awesome. A question from our side is, with respect to processing timelines for, let's say, your conditional green card at the moment, what has changed from 2022, late 2022, to versus someone who's filing in 2025? Because that will give the audience a very good understanding of who has benefited by making an early indoors into this program.
Sure. I'm just going to contrast a little bit with what happened, let's say, about a year and a half ago. I had a couple of clients who got their green card, conditional green card, start to finish in less than 6 months, which was fantastic, which was surprising. In fact, they got the green card even before the immigration could adjudicate their EAD and their advanced parole. So it caused a certain amount of confusion because they said, now I have my green card, what do I do with my EAD and the advanced parole? At the present time, we're still seeing projects with rural processing in about a year, I'm going to say, which is a lot longer than what we saw in 23, 24.
Sure.
And those with high unemployment, I think the average processing time is still floating between 18 and 24 months.
Sure.
So we are seeing that, but in my opinion, that's less relevant if you've been able to file the adjustment of status, because you're getting the benefits, like I said earlier, of the employment authorization document and the advanced parole, which are the benefits you want from the green card. So you're getting that. So I don't think, in my opinion, without giving financial advice, because I'm not allowed to give financial advice per SEC and FINRA rules.
Yes.
And I'm, again, disclaimer, not offering financial advice. I think the investors have to focus on the quality of the project and the quality of the regional center, especially when you're going to be able to file a concurrent adjustment of status. Maybe the consideration shifts a little bit, not away from quality, but speed of processing if you're outside the US and going to be going through what's called consular processing.
Sure. As an EB-5 investor today, if I want to kickstart this process, how can I fast track my EB-5 visa petition in terms of being able to secure a priority date? And does the concept of something like staggered investment help us to lock in that priority date in such a scenario?
All right, so just trying to break that down a little bit. When you say fast track, I am one of those who understands fast track as not compromising on the quality.
Absolutely.
Okay, so I want to be sure that we're on the same page on that one, right?
So
you're making a decision for two different things, right? While
Correct.
you're proceeding with actually processing your application.
Yes.
One is the regional center and the project.
Yes.
So you're focusing on the quality over there. And two, you're not submitting the application in a rush or a slipshod manner and saying, there's no question of saying, not in my books at least, of
Correct.
saying, baad mein dekhenge.
Correct.
Okay, that does not work for me.
Yeah,
Okay.
doesn't.
So we get that out of the way.
Yes,
so you've got, so fast track is based on what you can do.
Correct.
Okay. You can do staggered investments. And that comes from the law, which always allowed for monies to be in the process of being invested. So we know that exists in the law.
Yeah.
Pre-RIA, when the amount was $500,000, it was relatively easy for people to come up with that money.
Sure.
And you were within the Indian RBI LRS rules, which
Yes.
I'm sure your audience is already kind of familiar with.
And we'll talk a little bit about it
Yeah,
in our next
absolutely.
segment.
Yeah, absolutely.
Yeah.
Now we realize that the LRS rules are, at the 800,000 level, maybe they're a little more challenging to comply with.
Absolutely.
From that perspective, the regional centers, and it makes good business sense,
Absolutely.
have also adjusted and said, fine, we can do a staggered investment. The investor needs to talk to each specific regional center to figure out what the staggered investment means for them. How much time is the regional center going to allow for them to fund with the rest of the project, with the rest of the monies
Sure.
for the investment? So you've got to remember that, but staggered investments are allowed. You can file the application or the petition. I'm using the word application, more easy for investors.
Sure.
But the EB-5 application is actually just technically called a petition. You can file it as long as you comply with a couple of conditions over there, which we can discuss later if you want to, in terms of the money. But you can file it. Once you file it correctly, you're securing the
Priority
priority date exactly that you referred to.
Yeah.
And basically then you take it from there. But you should be willing and must be able to comply with what you're saying in your petition.
Correct.
So that's important.
So since we spoke about trying to lock in that priority date as soon as possible, one of the concepts is about staggered investments, right? Can you let us know what exactly is staggered investment? And is it allowed by the government?
Staggered investment. Let's define what that is. It essentially means, just the word suggests, you're not making the full payment of the entire $800,000 plus the admin management fee to the regional center. You're making part of the payment required, which is $800,000, plus whatever the admin fee is that's agreed upon between the regional center, the investor, whoever else may be concerned, in which the immigration attorney has absolutely zero role.
Absolutely.
Okay, so just want to be clear on that as well. Sure. So it's part of what's defined as in the process of investing. Completely allowed by RIA. It used to be allowed before as well. It was just not necessary before RIA simply because the amount was at $500,000, which most people were able to come up with in one shot. It was in compliance with India's RBI LRS rules, and that was fine. Sure. Now it's the amount at $800,000 plus is a little more challenging to come up with. It's also more challenging to comply with India's LRS rules, and therefore it's almost become a necessity for many, many people. Yeah. So it's essentially the agreement between the regional center and the investor as to what they can come up with and over what period of time they're going to pay the balance.
Correct.
There are definitely certain guidelines for that, which again, they should be aware of. When I say they, I mean the investor,
Yes.
because you do need to explain to the immigration at the time of the initial submission what the amount is that you're going to pay later, how you're going to come up with that amount, where is that money coming from, and an immigration attorney, in my opinion, has the duty to at least have a pretty good idea of what the source of that funds is going to be. I'm sure we'll discuss source of funds as
Sure,
we
yeah.
go down this path, but that's something that's important. So staggered investment has become a routine part. And one more addition, which I know is a bit of a twist that's been added on now, in some cases, which is probably more applicable for H1 people in the US, you do have the concept, and there are regional centers that will allow some sort of financing facility as well.
Sure.
I know that's not the answer to your staggered investment question, but just throwing it out there.
Absolutely. And I guess staggered investments are also an additional workload for the immigration attorney. Do you agree to that?
Oh, absolutely. I think the immigration attorney works the hardest out of everybody else.
I think
And we
there's
won't go
nothing
down that
discounting
path.
that.
Yeah, we won't go down that path.
Okay.
But yes, it does create additional work because you've got to make sure at a later point in time
Sure.
that the funds are properly coming in as per the original agreement, that you don't have any hiccups over there. And I think as any established attorney who's doing EB-5 for a while will tell you, hiccups and source of funds are synonymous.
Okay. Before we move on to the next segment, the last question in this segment is, since an EB-5 petition covers an investor, their spouse, and children under the age of 21, how important is it to lock the date of the child or the age of the child when you file your EB-5 visa petition?
Well, your question suggests it straight away. Super important, because if you don't lock it in, that child who ages out, and I don't think we're getting into the nitty-gritties over here, because the age of 21 is not just referring to the biological age.
Sure.
It refers to an age that is to some extent fictional, because the law allows for what is called the CSPA, which is Child Status Protection Act, which allows a child over 21 to qualify as well, provided certain conditions are met. So the age of the child, the processing times, lots of these variables have to come into play. And therefore, it's really important for people who, for lack of a better word, procrastinate in terms of filing the petition, and maybe for very valid reasons, don't have any issues with that, may lose the ability to have their eldest child
Covered
migrate. And when I say eldest, it could be child number 1 and child number 2, or whatever the case may be. Have them not covered in the EB-5 application. And then that becomes sad. And obviously that may force an investor to do, or the need to do, multiple EB-5 petitions. I have a client who has done 3 and is ready to do the 4th. But that's a different kind of client completely. But most often you do want to try and get the family in together.
The RIA as such is valid up until 2027. And for those investors who file on or before 30th September 2026 as their conditional green card petition, will be protected under this law. What are the changes, or what happens for someone who files after 30th September 2026? And historically, as someone who's been in this industry, have you seen EB-5 as a visa program go through its ups and downs in terms of not having an authorization, or just those challenges that you would have faced? So that is something that we'd love to hear from you.
Sure. Again, multi-part question. Let's talk about the past and then we can talk about the future. So there have been times in 2016, 2017, 2018, where the program was supposed to sunset or end on September 30th of a particular year because the extensions were not passed. That certainly created a rush, created a nightmare for everybody. And then at the last minute, it would get passed and it went through. Of course, we all remember there was a gap between September 2021 and RIA when the program did actually end, and people didn't know what was going on. So it creates the uncertainties. Those uncertainties, to a large extent, have now been addressed by RIA, which says that if you filed your petition on or before September 30th, 2026, like you correctly said, you're grandfathered. So it doesn't matter if the program gets extended or not. We certainly expect the program to be extended despite a lot of conversation and fears about the new administration's possible reactions or actions with relating to immigration laws. The answer, in my mind, so if you've applied, like I said, on or before September 30th, 2026, you're good to go. What I don't know the answer to, and what I don't think has been addressed by the immigration, and which I think not only needs to be addressed, but it's just a common sense question.
Sure.
So what happens if I file on October 1, 2026?
Yes.
Am I not protected? Are you still going to take my money? I cannot see a regional center not taking $800,000 because we don't know what's going on. So there's probably going to need to be some clarifications from the Immigration Service as to what happens for applications filed on or after October 1, 2026. We hope that even prior to that, there'll be an automatic extension or some kind of an extension to the law so that it allows one to proceed.
Absolutely.
But one thing you also want to keep in mind at that point in time, the amount of investment may well go up.
Yes.
Because that's supposed to change every 5 years. So that's effective October 1, 2027. It's supposed to be adjusted based on cost of living index and other variables. So there are lots of, again, questions as to what happens to applications filed on or after October 1.
Yeah.
From that perspective, and a whole bunch of other factors like the visa bulletin, concurrent adjustment of status, retrogression, all of that, it seems that it would be in the investor's best interest to file the applications on or before September 30th, 2026. And that means don't wait till September 29th.
Awesome.
2026.
Yeah, because the idea of talking about this is to actually educate our investors that just like how the investment increased from $500,000 to $800,000, there's a very big possibility, since it mentions that the amount can be and will be adjusted as per inflation. If investors don't apply before 30th September 2026, as you rightly said, they could pretty much be looking at a larger investment amount.
Correct, absolutely.
All right, moving into segment 3 of our podcast for today. Source of funds as a key concept and impact of taxation and foreign remittance laws in the journey of an EB-5 investor. The most favorite question: what exactly is the meaning of source of fund? In simple words, I know it's
is it your favorite question or my favorite question? Because that's the reason for my existence, I suppose. Source of funds and what we call the path of funds.
Yes.
So it's a great question because very few people, and I'm not blaming them at all, do not understand what source of funds means from an EB-5 perspective. I mean, obviously at a simple level, everybody knows is where did the money come from. And if it comes from a bank, everybody presumes that the money is legit and can be accounted for. But that's not the definition or the explanation or the interpretation by the Immigration Service of source of funds. They are very concerned about the origin of the funds. They're very concerned that the origin itself should be credible, should be legal, should be legit.
Sure.
And I'll take a very simple example to prove a point. As we all recall, when there was demonetization in, I think, 2019 or whenever it was last done over here, right? Yeah. You were allowed to make certain deposits into the Indian bank account, and it was, as long as it was declared, you will pay tax on it, and then it was fine. It was legit, which was perfectly legal, not a question at all. Yeah. However, from an immigration and an EB-5 SOF perspective, that did not tell me where the money originated from. And therefore, that money could not be used for EB-5. Yeah. So it's hard to digest that now my money is legal, but you can't use it. Yeah. Okay? But that is just an example. So you've got to be able to trace it back to its origin, which is always the hardest conversation. It's always the hardest exercise. It's the most time-consuming exercise. And I can tell you that every one of my clients will always say, my source of funds is clean. It's coming straight from the bank, which is great until they actually get into the weeds. Yeah. And I cannot tell you how many clients then begin to appreciate how difficult it is to do the source of funds.
Absolutely.
There are times, very often, that I work with a chartered accountant, either the client's chartered accountant or a chartered accountant that I may have a connection and a relationship with, especially one that I work with who's out of Delhi. Just trying to get it done and explaining to the clients. I've had clients where their support team has sat with them through the night over 2-3 days, where this chartered accountant has flown to Bombay or flown to Bangalore and sat with the client for 2-3 days trying to sort it all out. It can be very confusing. It can be very challenging. You then get into the concept of commingling of funds and how do you trace that money back? It is an exercise, and what I would say is no investor should underestimate the effort that's involved in putting that together. It's shocking.
And for the context of our audience, it's also pivotal because the basis of the government giving you your conditional green card is on the basis of how good and well done is your source of fund petition. Is that understanding correct?
Absolutely.
Okay.
If I had to look at it in terms of cuisines, I would say you want your source of funds, in my opinion, to be presented like a French dish.
Sure.
Because I truly believe the simpler you can make the presentation for the immigration service, the less the chances are that you will get what's called a request for evidence or further clarifications.
Sure.
And just because I follow that philosophy and practice, I'm kind of happy to say that out of over 300 applications that I've done, there are less than 15 that have been kicked back for a source of funds.
Sure.
They may come back for other questions, but not usually for source of funds.
And RFEs at time could be very simple RFEs as well.
Yes.
Something that investors feel, they feel frightened when they hear about an RFE. But I guess with experience we've learned is what is mentioned in the RFE is most important to see and not get frightened just because you got an RFE.
Absolutely. 100% correct. And sometimes I'm always happiest when the RFE comes in and is asking for project information and nothing to do with source of funds, because that means I did my job.
Absolutely.
Yeah. So yeah.
One of the common concerns or questions is that while there are a lot of immigration attorneys in the US, we want to educate our audience and let them know why is it important to go ahead with an attorney that is experienced in the world of EB-5. So if you could just help us understand why is it important to go ahead with an attorney that has decades of experience in EB-5 and not just someone who probably takes care of all visa programs? Because everyone's not an EB-5 expert.
Sure. And I'm going to start out by saying it would be incorrect for me to say that there's no starting point. Everybody has a starting point.
Yes.
So I'm certainly not in any way minimizing or reducing the responsibility and the importance of an attorney who wants to get into EB-5. That's fine.
Yeah.
You eventually get the years of experience doing more cases.
Yes.
And that helps you navigate the EB-5 world a lot more effectively and a lot more easily than somebody who's getting into it for the first time. Again, not to take away anything, because all of us had a starting point, and as long as you're working responsibly and with your ethics that you're required to comply with, I think it's perfectly fine. Obviously, the more experienced the attorney is, the more likely they will see the holistic picture, they will be able to anticipate questions, and they'll give you the benefit of their wisdom and their experience. So definitely, it is important to have somebody who's done this in the past. Again, do not mean to take away anything from somebody who's starting out in the field, because there has to be a starting point for everybody.
And as far as I've seen this industry, I think EB-5 is a very welcoming industry. People like you, colleagues like you. I still remember the first time I met you at an event, and I told you this is my first ever panel discussion, and you were so welcoming. So yeah, I just want to put it across that there is obviously a benefit of going with someone who's experienced, but at the same time, we're a bunch of people who are welcoming, and this is an industry for everyone to look at.
Totally agree, yes.
In terms of laws, especially that we're looking at fund transfer from India, you mentioned a little bit about LRS. So could you tell us a little bit about generally FEMA, TCS, and LRS as brief concepts for the understanding of our audience?
Sure. I think what's most relevant is the LRS, which stands for the Liberalized Remittance Scheme.
Yes.
Under which, as an Indian resident, you are allowed to transfer out up to 250,000 USD every financial year.
Yes.
That's an allocation for each individual. And that is irrespective of age. So that's important to remember, that even a very young child is allowed to transfer out money up to $250,000 per person per year.
So I need not be an adult. Like I need not be an 18-year-old adult.
Absolutely correct.
Okay.
Absolutely. I've done it for children who are less than 3 years old.
Wow.
So that's what the law allows. So
Sure.
You're complying with the law.
Yeah.
FEMA is, of course, the Foreign Exchange Act, which you need to make sure you're compliant with, and that is super important to make sure you don't get onto the wrong side of the Indian laws.
Yeah.
And again, from that purpose, you should always get expert guidance in India from an Indian attorney who does that. Fortunately, having been born and raised in Mumbai and studied over here, I'm very fortunate to have some very good contacts with excellent FEMA attorneys in Bombay who can always guide my clients. And very often I will tell them, go first talk to them, make sure you're complying, then we can continue with this conversation, because that is super important again. TCS is relatively new. It's probably, I think, just about a couple of years old.
2022.
Yeah, and I think it was the implementation may have been postponed for a year, but now it's in effect, so it doesn't
Yes.
really matter.
Yeah.
If you're a resident who's transferring money out of India, you are subject to paying 20% as a withholding, which I think you get back when you
Yes.
file your tax returns for that appropriate year.
Yeah.
Again, important to discuss with your immigration attorney who knows about this. Important probably to discuss with your chartered
Chartered
accountant in India who can
Yeah.
guide you on this. This is not the place to follow or to subscribe to a U.S. attorney's guidelines on this. You want to make sure you're complying with the Indian laws.
Sure. Before we end this segment, a common FAQ is it okay by the USCIS if I borrow funds from my friend, family, or relative? And is it okay, or does all the funds need to be sourced from the US itself? So can I not just transfer funds from India, but if I have relative in Singapore, can he lend funds to me? And how does USCIS look at that?
Okay. Quick answer is yes. Let me expand on that though.
Sure.
First answer is the money can come from anywhere in the world. It does not have to come from the United States. Most importantly, again, is the documentation to prove where that money came from. I'm not a big fan of friends, if you break it up into friends and family.
Yeah.
Simply because how many friends give you that kind of money is question number one. And I think that's just a natural question that one asks.
Sure.
India is also known to have different sources of funds, and I would not necessarily want to expose myself, and the friend may not want to expose themselves to being asked too many questions.
Sure.
Because whoever is giving you the money, whether it's a loan, whether it's a gift, it doesn't matter, has to show where that money came from their sources, which means they need to open up their finances. And I don't know how many people, how many friends are willing to open up the finances for a friend to help them along. So when somebody tells me that they want to do a friend loan or a friend gift, and if that's the only way that they're going to go, I want to talk to that friend and I want to make sure that friend understands what he or she is getting into. And why am I doing that? Because my job is to protect my investor.
Yes.
If my investor gets me the monies and I don't clarify to that friend that there could be an RFE from the immigration, and you're going to be needed at that point to give me more information, and at that point, I don't care whether you're still friends or you're not. But my interest is protecting my investor.
Sure.
I want to be clear on that side. So that becomes quite an issue. So that's the reason why I'm not a big fan of that. Even when it comes to family, unless it's parents or siblings, when you start talking about mama, chacha, kaka, how many of them are going to be willing to support an RFE if it comes in? That's always a concern. How many of them are going to be willing to open up their books? I do see it on occasion, but I don't see it too often. So yes, that's why I said the quick answer to your question is yes. One caveat over here, and maybe I'm anticipating the question, so I'll just beat you to it over there. A lot of people who are in India will say, LAP leke paise bhejta hu. For those who are not listening to Hindi, the loan against property, which happens in India very commonly, I'm going to use that.
Sure.
That's a no-no. That's a question that comes up a lot. That's a no-no simply because since about 2018, I'm going to say the RBI has clearly clarified that if you're taking a loan against property, that's not going to be remitted outside the country.
Sure.
There are different permutations, combinations that have been experimented with. And as to the best of my knowledge, they have not passed muster. So that's something that's not available. And a lot of people will ask that question, and which is reasonable.
Sure. Thank you. In our next segment, we look forward to asking you to share your clients' experiences and how a timely application helped them achieve probably a faster priority date or their green card. So, if you could just give us a few examples of probably someone on an H-1B or an F-1 or someone from outside the US doing a consular processing, it would be really helpful for our audience.
Okay, great. Let's take the one that's most common where people are on an F1.
Sure.
They're on an F1, the OPT is getting over. I had that kind of a situation recently. And as we all know, OPT refers to optional practical training, which is allowed under the immigration guidelines after you graduate with at least a bachelor's degree. They were in their last 60-day period, which is the end of the OPT plus the 60 days, which is what is allowed again. We had to file it before that 60 days ended because they had no H1, they had run out of their options, and their only option was to file the EB-5 with a concurrent adjustment of status.
Sure.
Why is that important? Because once you file the adjustment of status, you are then allowed, I'll change the word allowed to required, to remain in the United States until certain steps take place, such as getting the advance parole. But the bottom line is the individual can then stay in the United States, which is what their goal is, which is the only reason why they're doing the EB-5, because they want to make this their permanent home. So that is important in terms of being able to file it in a timely manner, meaning before the OPT period ends, right? Okay. On an H1 situation, again, you're also tying this in with the availability of priority dates and the
Correct.
fact that the adjustment can be filed.
Yes.
There are lots of H1B people, I think you know and I know, who are a huge market at this point in time because of the concurrent adjustment of status or the ability to file that. They realize that they're going to take about another 50 plus years to get their green card if they're waiting through the employer. But they've been able to accumulate the wealth, whether it's on their own through their employee stock options, RSUs, etc., or combine their ability with the parents' ability to give a gift and file the EB-5 so that they're not relying on the H-1B at that point in time. Just want to clarify for viewers that you can have a H-1B and an application for your EB-5 and adjustment going at the same time without compromising one or the other. But it's important that they can, that they can file it. So from an H-1B perspective, it's great because you don't have to meet certain timelines and it kind of opens up the doors for you. Trying to think of who else that I can think of. And I think I referred to that in one of the earlier segments. I had a client who had come in on an F1. We had filed the EB-5 petition, and we waited the required amount of time before they were qualified, and then circumstances allowed them to file the adjustment of status.
Sure.
And they got the green card in less than 6 months.
Wonderful.
So that was fantastic. So you always have positive stories for this. There's no question. Even for consular processing, I'm going to say that pre-RIA, there was a regional center that was kind of promising a quick green card to a lot of people.
Sure.
And I did not have any investors in that program because I thought that there was not the right amount of the proper information being given.
Sure.
And I've had clients who invested over there and realized that what was being said was not actually what was happening.
Sure.
There was certainly a gap between the marketing and the reality. With all due respect to you, it is important, I think, from a client's perspective to be able to separate the wheat from the chaff and figure out what's going on. And therefore, you need to discuss that with your immigration attorney as well.
Sure.
And I think, again, from that perspective, I realize I'm digressing a little bit, but an investor must be careful when they're engaging their attorney, again, to make sure the attorney is representing them and there's no conflict of interest.
Absolutely.
That's important.
Absolutely. Yeah. And at the same time, we've also seen cases where we kept telling the investor to file the petition, but as you said, for some or the other genuine reason, they couldn't. And by the time they did realize, the elder child got aged out and then they had to file 2 petitions. So again, the point being that if you can, and if you have the means, and if you have the guidance in the form of great immigration attorneys as you, feel free to go ahead and file your EB-5 petition as soon as possible.
Totally agree. Of course, I'm not going to complain if an investor wants to file 2 petitions. It's my job. But again, that's not what you really want the investor to do, because I
Correct.
think, again, digressing or extending it over here a little bit, we all have to realize, and I point this out to investors all the time, they must understand the basics of the immigration program for EB-5. There is no guarantee of the return of your money or the guarantee of the return on your money.
Correct.
The word guarantee does not exist in the EB-5 lexicon. Absolutely. And I repeat that to the investors over and over and over again.
Yeah.
Plus, I think it's important for the investor to know that the money is going to remain at risk roughly for about 5 years.
Absolutely.
So the present law, which says that the money, and I realize I'm digressing, but I think it may be useful to point out to them that the present law says that the money needs to be invested for 2 years.
Yes.
But one, there's a lot of conversation, lawsuits about what that 2 year really means.
Yeah.
Okay.
And it's still work in progress.
And it's still a work in progress. There are conflicts of interest right there in the definition. From an investor's point of view, the 2 years should start from the minute I sent the money to you.
Yeah.
From a regional center's and a developer's point of view, that makes no sense from a business perspective. And the immigration has at least tried to clearly say, we care about 2 years. Whatever agreement you may have with the developer and the regional center is none of our concern. If you need to lock your money in for a longer period of time, that's between you and them. So they've left this field wide open. It's like a swamp, or it's a sinking sand at this point in time.
Yeah.
But so I always tell the investors, expect your money to be locked up for 5 years. If you get it back sooner, nobody's going to complain.
Correct.
If it takes you at least 5 years, then you know that you were warned about that. You should not get into this saying, I need the money back 3 years later because my kid is getting married and I need to use the money for that. Or my kid is going to a master's degree and I need the money back to fund that. That's a bad idea. So you need to be careful.
And I think that's where honesty in terms of, putting out everything to the investor, cautioning them, letting them know is most important, because at the end of the day, it's a relationship which is going to last for 5 to 6 years, right? So it's not about just taking the money and then just, forgetting about it. When an investor invests with you, whether with an immigration attorney, working with an immigration attorney, or investing with the regional center, it's a relationship of 5 to 6 years. So you want to be on the right side of that relationship, and you want to ensure that you do justice and you do well for your investors.
Totally agree. I mean, it doesn't matter, in my opinion, it doesn't matter whether it's a relationship of 6 months, 1 year, or 5 years. The stress is on the word relationship.
Correct.
Yeah. And there can be situations where there'll be a little up, a little down, but sometimes when there's a down, you come out with a much stronger relationship. Life is full of challenges.
One of the most favorite questions in today's time is, with the new government, there's a lot of anticipation, anxiety about what happens to the EB-5 visa program. Any thoughts on that as an immigration attorney?
Sure. Short and sweet answer, I'm not expecting anything negative to happen with the EB-5 program. One, it's the law. It's already there. Secondly, think about the amount of money it brings into the United States. It's free money, because I think it's fair to say that the regional centers pay almost nothing to the investors. It's usually a 0.25, 0.5% simple interest. So it's money that's coming in. It's creating jobs in the United States, which may be in line with the present administration's desires.
Sure.
And all of that just tells me that EB-5 will not be touched. The focus of the present administration is much more on the undocumented, the criminal aliens, and EB-5 is obviously very far from that.
Yeah.
So I don't see any negative impact on the EB-5 program. Where I do have a concern is if a lot of the federal employees, if the core of the federal employees, the number is reduced, and there are less people to do the work and the adjudications, that may have an impact on the processing times, but I don't think it's going to affect the EB-5 program. Now, the flip side over there is, if the processing times are taking longer and the visa numbers are not used, it may take longer for retrogression to hit.
Sure.
So it's an argument where, you've got the flip side, which is good, and you've got the flip side that is bad. So it's almost like the Ram and Ravan kind of story.
And the longer it takes, the priority date sort of stays current for longer, which means that people can
Exactly.
still continue to file
Exactly.
their
But that
adjustment
is,
as
but that
status
is, you've got to take that as my personal thought, and
Absolutely.
you've got to be cautious. Don't postpone the filing of the EB-5 petition in anticipation that it's going to take longer to process, and then you suddenly miss the boat on the adjustment of status. That's obviously to the detriment of the investors and the families. So I'm certainly not suggesting that. I'm just giving you a flip side personal opinion on that. So I think EB-5 is a good program. It's here to stay, and I'm sure that you would agree that it's helpful to the economy. It serves its purpose. It's
Yeah.
meant for the economic benefit and job creation. And I think it's doing its job very well for the United States.
I'm sure. The US continues to be a land of opportunities. The EB-5 visa program continues to be the fastest and the most credible way of achieving your US permanent green card. We hope that this podcast today was helpful for you to know why is now the right or the best time to file your EB-5 visa petition. Rohit, I'm genuinely grateful to you for your time. Your insights are always valuable. Thank you so much, and it was a pleasure to have you on our podcast today.
My pleasure and privilege. Thank you so much, and hopefully we'll do another one soon.
Absolutely. Stay tuned for our next episode of EB-5 Essentials. Take care and talk soon.